In the final two lessons on the subject of non-fatal offences, what I want to do is talk about grievous bodily harm. Both grievous bodily harm in its general form, as well as grievous bodily harm with intent, which is the last of the major non-fatal offences we're going to be covering. After this, we're going to start looking at dishonesty offences, so we'll talk about theft and fraud mainly for the most part, before we start to talk about defences to these various crimes, whether these be capacity defences or whether these be necessity defences. So we're going to spend some time talking about what grievous bodily harm actually represents, and it is outlined in Section 20 of the Offences Against the Person Act. So one point of reference that we should note at the outset is, while the offences that are of non-fatal offences, that if we were to rank them in terms of scale or in terms of severity, we would start with the later provisions of the Offences Against the Person Act. So Section 47 is assault occasioning actual bodily harm, and then GBH is Section 20, and then I believe Section 19 is GBH with intent. So you actually go down in terms of numbers of provisions, but then you go up in terms of severity. That's one point of reference that we need to note here. So, the 1861 Offences Against the Person Act defines in Section 20 grievous bodily harm as follows. They say that, this is what the title of the legislation is, or the provision, should I say, inflicting bodily injury with or without weapon. Whosoever shall unlawfully and maliciously wound or inflict any grievous bodily harm upon any other person, either with or without any weapon or instrument, shall be guilty of a misdemeanour, and being convicted thereof shall be liable to be kept in penal servitude. Again, some language that we do not use anymore. Penal servitude is one such a language. And also, the word misdemeanour is also language that is used in the States quite a lot, but is not used in English and Welsh law very much. So that's a point that you need to note there. So, grievous bodily harm, as stated in the Section 20 of the Sexual Offences Act, can be done in one of two ways, both with an element of maliciousness. This represents the mens rea, the maliciousness of the offence. It can either be done through wounding or through inflicting grievous bodily harm. What do we mean? Well, wounding requires some kind of break of the skin, as cited in the 1984 case of JCC versus Eisenhower. That's what wounding represents. So if you wound somebody, you're breaking the skin, and in doing so creating a wound, whether that be through a knife, through a pair of scissors, through a fork, anything, okay? Inflicting grievous bodily harm is a little bit more broad. It refers to those things that are severe enough to actually be quite a severe form of damage against a person, but not necessarily something that breaks the skin. So it's a little bit more complicated. It is seen to be inflicting, quote, serious harm. That is what inflicting GBH essentially involves. If you want to just replace the word GBH to mean serious harm, you would get that kind of definition. Ultimately, what constitutes serious in this definition of serious harm is something that isn't necessarily too easy to ascertain, but the jury is able to be instructed as to the meaning of serious for the purpose of finding a determination. So the jury may be instructed in cases by the judge as to what is representative of serious harm before they make a deliberation on whether or not the harm in question in that case represents serious harm and therefore represents grievous bodily harm. Now, the Crown Prosecution Services, or the Crown Prosecution Service, should I say, have quite a few charging guidelines. And in the charging guidelines for the CPS, when it comes to this issue of GBH, they list a number of examples of what serious harm could constitute. And this is one of those things that really we should just be given a number of examples to get an indication of where serious harm actually is, rather than having a strict, definitive, conclusive definition as to what it represents. So the CPS charging guidelines say that serious harm can include a substantial loss of blood, something which will require either a lengthy treatment or incapacity. so some kind of a damage to somebody that causes lengthy treatment or incapacity, some kind of permanent disability or a permanent loss of senses. So if you were to get into an altercation with somebody and you cause them to lose an eye as a result of your actions, then this would probably this would definitely represent GBH, because it would represent some kind of permanent disability or some permanent loss of the senses. Visible disfigurement, again, would also be represented in the previous example that I just noted. If you cause somebody such damage that it causes them to be permanently visibly disfigured as a result of your actions, this also represents GBH. Also, we can think of broken or fractured limbs representing part of GBH as well. This is all cited, by the way, in Herring 2022. So, this includes all of the other things that aren't the breaking of skin, because you can cause somebody to lose a substantial amount of blood, or require some kind of lengthy treatment or incapacity, or cause a permanent disability, or cause visible disfigurement, or cause broken or fractured limbs without breaking the skin. You could do all these things without breaking the skin. So while it wouldn't constitute wounding for the purposes of GBH, it would constitute the inflicting of serious harm or inflicting GBH for the purposes of Section 20. So those are the acts, those are the things that are done that represent GBH. What about the mens rea for the offence? Well, it is contextualized and incorporated in the word maliciously in Section 20 of the legislation. That's where the mens rea lies. Now, again, this requires either an intent or a recklessness to cause some kind of harm. However, there is not a requirement that the defendant intended to cause the level of harm which would amount to GBH, just that they foresaw some harm as a result of their action, or even intended some harm as a result of their action. Whether or not they intended to cause GBH is irrelevant to a finding of GBH. Because if they intended to cause just some harm, they intended to hurt somebody. Let's say they intended to punch somebody in the face, and then they end up breaking their jaw and permanently disfiguring their face. The actual intention might not have been to cause GBH. It might have just been to cause a form of ABH. But the result was a series of events and a series of factors which would fall under and constitute the inflicting of GBH for the purposes of the legislation. It should also be known that harm can be psychiatric harm as well if taken to a certain level of severity. Again, the level of severity is what is required here. The case of Burstow from 1998 illustrates this point. It was very similar to the case of Crown versus Ireland, which is what we talked about in previous lessons with the phone calls, the silent phone calls where the individual constituted, it was constituted to be an assault on the basis that it did cause an apprehension of harm. So it was similar in that case, except the levels of harassment in the case of Burstow was actually far, far, far more extensive. The defendant made silent phone calls, like in the case of Crown versus Ireland, made and sent menacing cards, followed the victim to work, etc., etc., etc. The defendant himself had actually been in a previous relationship with the victim. When the relationship had ended, they went on this harassment campaign on this extensive level. They basically went on this unhinged campaign against this poor individual. And the psychiatrist, should I say, testified that the result was the victim suffered from extreme psychiatric harm. Namely, they went through a depressive illness as the result of the sheer levels of harassment that took place. And so, the court held that Section 20 could be satisfied as the result of these actions. It was argued by the defence that this could never amount to GBH because GBH requires either wounding, obviously there was no breaking of the skin in relation to these events, or causing and inflicting GBH, inflicting serious harm. Now, the CPS guidelines do not include, or at least did not include, psychiatric harm as listed in this a number of things that could constitute GBH. And so the question was, could psychiatric harm fall into this remit? And they held that yes, the word inflict, when we talk about infliction of GBH, does not mean that the infliction was direct. It merely says that infliction should happen. And so to cause somebody to have such harm done to themselves, i.e. depressive illness, a psychiatric development of a psychiatric injury, could mean be an infliction for the purposes of Section 20.